Morning, neighbors. This is a message from your community law firm here at Carmel and Nakasha to discuss the law and your website. I regret to inform you that nationally there's been a 42% increase in lawsuits filed against companies on a national level claiming that their websites do not provide equal access to those with visual and hearing disabilities in violation of the American with Disabilities Act. There was just a lawsuit filed just a few weeks ago against a dental practice in Ventura County, filed against a self-described civil rights advocate for the disabled, stating that the website of the dental practice was not compatible with the plaintiff's screen reader. There's pending ADA lawsuits in San Luis Obispo County. This is problematic because it is estimated that over 90% of websites do not provide equal access to those with disabilities. This is problematic because law firms often target smaller businesses for an easy, early payout because they know they don't have a large legal team behind them to fight it. So some of you smarty pants in the room might say, counsel, I object. I know that the ADA only covers places of public accommodation. This is a website. So does any of you know, is a website considered a place of public accommodation? I could answer and provide you a legal analysis for 30 minutes. I find it very fascinating, but I won't. I believe that's part of my speech, don't worry. I want to say there's a lot of legal uncertainty to answer that question. That answer is different in Connecticut, it's different in Wisconsin, it's different in California. There's a big split of authority on the federal level. The Supreme Court of California and the US, who love to shake things up, both of them, have yet to rule on this issue. Sacramento's involved and wants to totally change the law in California. So is a website considered a place of public accommodation under the law? The answer really is yes and no, and well, it depends. So what do you do? How do you protect your company and reduce the risk of ADA lawsuits and not get sued? We don't want to get sued, right? Well, one, educate yourself. There are internationally recognized guidelines on website accessibility called the WCAG2, Web Content Accessibility Guidelines version 2.0. Look that up. There is informative content online to help you understand. There's what's called the POUR principles. Look it up. Perceivable, operable, understandable, and robust. Once you've educated yourself and cross-compared with your website, talk to your web team, your web developer, your web designer. How can you actually implement those POUR principles to your website? This might be adding closed captioning to your video content, adding alternative text to your pages. It might be providing better color contrast for a better visual enhancement for the visually disabled. You might want to hire a visually disabled tester to provide you feedback. And next, conduct regular audit with your web team. The tech, the accessibility standards are constantly changing, and the law is somewhere behind trying to catch up and also changing. So make sure that you are changing accordingly. I know that sounds like, oh gosh, it's going to cost me a lot of money and time, but believe me, it will be a lot cheaper than a lawsuit down the road, okay? And a lot of these practices are not just for folks, web users who are considered legally disabled. It is a better web experience for your potential customers and clients, for everyone. Just, I love a web page that says, read this page. It makes my life a little bit easier and gives my eyes a break. Also, add an accessibility statement onto your website. State what you have done specifically and what you are in the process of doing for enhancing the experience for those with disability. Next, this is a big one, insurance coverage. Find out if this is covered by your insurance policy. Talk to your insurance broker if you're unsure. Some policies have an express exclusion of ADA policies or ADA claims. If your website is a big integral part of your business, it makes sense to spend some extra money and supplement your coverage. Next, act promptly. If you get a demand letter, you get served with a lawsuit, tender it to your insurance regardless of whether you know it's covered. My firm is dealing with several disputes of insurance companies just denying coverage, saying, oh, sorry, you didn't promptly tender this to us, even a suspected claim. And talk to a lawyer ASAP if you get a demand letter or get served. I know I just provided a lot of information. Talk to your lawyer if this seems overwhelming. Talk to your web team for further answers. I'll be here afterwards to answer questions. You can give me a call. I'm Emilie De Lamont, Carmel, and Natasha, and let's try not to get sued out there, okay?